having been transferred pursuant to orders by Justice Ogora made on 4th April 2024, and the mentioned parties organizations are now to proceed with the matter, especially on the issue of representation in the matters that originated from Machakos High Court in light of the notice of change filed by the petitioner, alongside a notice of withdrawal of petition. Mr. Moody, learned counsel for petitioner, submitted on the issue of representation between himself and Ms. Kariuki. He stated that the issue be determined first. On her part, Ms. Kariuki maintained that the change of advocates would not take effect until she is served with the notice of change. Ms. Kariuki further stated that her client, the petitioner, had disappeared and that she had been unable to reach him. In a rejoinder, Mr. Moody informed the court that the petitioner was on his way to court and that there would have been a police report if indeed the party had disappeared. This court notes that the petitioner later appeared in court today in person, and he confirmed that he had indeed changed advocates on 28 March 2024. I have perused the proceedings of 4th April 2024. That is the proceedings before Justice Ogola, and I note that the issue of the notice of change of advocates arose before the state judge, when the issue of withdrawal of petition also arose. I note that Ms. Kariuki was in court on the state date. I therefore find that she must have had notice of the change of advocates. Having noted that the petitioner appeared before me in person and confirmed that he had indeed changed advocates, this court finds that the change of advocates took effect the moment the same was filed in court. In sum, I find that Ms. Kamuli, advocate, is properly on record for the petitioner, which means that Ms. Kariuki is henceforth excused from these proceedings. Those are the orders.
I was only seeking a clarification on the withdrawal of suits pursuant to my instructions.
I'm not dealing with the issue of withdrawal now or today. I was only giving my ruling in respect to the issue of representation, which would then clear the way for the other issues to arise. I think that is the proper way to go. Yes.
Very well guided. I'm guided, my lord.
Yes, since now you have clarified the issue of representation, what do you want to do next?
But no,
or do I start my weekend?
What I'd like to do next is to request the court to adopt my notice of withdrawal of suits as judgment of this court. What happened to this one? What do we do that? My Lord, I'm seeking the adoption of my notice of withdrawal of suit dated 28th of March 2024 be adopted as an order of this court.
Yes, I've heard you.
I have no more instructions.
Your leadership for good order and measure. As much as I know none of us have outlets, maybe perhaps those supporting the withdrawal should go fast, but perhaps then one then opposing can then respond.
But you must say you have no audience. So
Oh.
But the difference is the first person who has audience is yourself.
None of us.
And you have exercised that option by saying we are not dealing with the issue of withdrawal of material unless you have a change of mind.
No. I just wanted Mr. Moody to say, has he said, because this is his master.
Yes.
It would have been good for me to just walk out after delivering my ruling.
Okay.
I just wanted
My
to hear
lady.
from him before I move.
Yes, ma'am.
Yeah.
Now, my lady, if we are not dealing with the issue of withdrawal today, there are two issues then that come up, my lady. One, in terms of the orders from Justice Agola of 4th of March, is whether you have all the files, and if you don't have them, probably we schedule a date when we have all of them, so then you can give directions on the totality of the matters. That's as the first position we will take. We would suggest to you, my lady, because it's coming up for directions today. Then the second one, my lady, is the judges, your predecessor judges, including Justice Ogola, determined that the interim orders, conservatory orders, to do obtain until we reach a point on the parties hearing. We will pray that the interim orders that are in place do remain in place until the time they will have scheduled to the parties and determine. And lastly, my lady, okay, again, my lady, Mr. Muli. My lady, I appear for the petitioner in petition number 3 and petition number 4 of 2024, Kisii petition number 3 and Kisii petition number 4 of 2024. I appear together with Mr. Ochoki and Mr. Ndegwa. It's part of the files that were consolidated in the orders made by Justice Ogola on 4th of March, pursuant to the court's powers under Rule 17, enabling the judge to consolidate orders that relate to the same matter. That's all I wanted to say for now. I'd say lastly, probably we need to determine the question of consolidation, which we are proceeding to address, and join that. And the identity of the parties who are petitioners, who are respondents, so that when we address you, your record can be neat knowing which petition it is in the consolidated petitions. That's all I have to say.
Okay, Council, as much as, let me just say something, as much as the matters are consolidated, I think each petitioner has their own separate cases. My understanding is that every petitioner will be having their go at it. The purpose of consolidation was really just to bring everything under one roof, so that we don't have one case going on in Machakos, another case going on in Kisii, another case, I don't know, there's another one in Milimani Commercial. So I think the purpose of consolidation is clear to all of you. So, as I've said, I will not deal with the issue of withdrawal or petition right now, because this is the first time I'm interacting with this case. I don't know under what circumstances the matters were transferred to this court. As of now, I don't know what has been going on in Kisii, if the matters have been heard, if they are fresh matters, if they are pending rulings, or if they are pending judgments. I don't know. This is the first time. In fact, when I came into court, is the first time I was seeing these files. So I think it is just right that you give me time to look at the files. I will give you a date, a return date, when now I will be in a clearer picture on, and I can give you better directions on how to proceed.
If it is, I love the clarity.
May I say something?
Yes, Mr. Ndegwa, you wait until I come. Yes.
This is Mr. Theuri. I think, unfortunately, sometimes when you appear online, those who appear in physical court tend to get your attention much easily than we do.
That is not intentional, Counsel.
Yes, my lady. I know that I'm not imputing any improper motives on the part of the court, but I'm basically saying that
yes,
we are also here and we would want to say something. But may I just perhaps put you into context as you consider, because at this point you would be considering what directions to give. But there were two petitions, that is petition number E006, that is now the petition number 001 that you are facing, that is before you. This petition was filed in Machakos. The court granted interim orders and transferred the matter to the PJ in view of the fact that the court did not have geographical jurisdiction. And so that is the reason why that file was referred to your brother, the PJ, as the administrative head of the High Court for purposes of giving directions. Your brother, the PJ, when giving directions, transferred this matter to your court. That is formerly petition number E006 that was filed in Machakos. Subsequent to the petition in Machakos, there is another petition, E007, that also has interim orders, and in a similar manner, the High Court sitting in Machakos found that it had no geographical jurisdiction, but it transferred the matter to the PJ, again for purposes of directions, so that the matter can be allocated to a judge, and that matter was allocated to you. My lady, my understanding as you were talking is that you perhaps may not be having that file.
Yes.
Now, those petitions, the Machakos petitions, allow me to refer to them as the Machakos petitions, were filed during the pendency or were filed later than petition number 03 of Kisii, E003 of Kisii, and E004 of Kisii. And because the same arise from the same matter, the court was of the opinion that they should be hanged together with the other petitions that were being transferred. And so already part of the duty that you have would be to call for those two files that were pending in Kisii for purposes of giving further directions. Already one of the things that we will be raising would be whether that was a proper exercise by the PJ in view of the fact that those files were not before the presiding judge at the time that he was giving directions at later point. Already, there was also another petition, that is petition number 159.
Yes,
of
slow down,
2024.
Just slow down, Mr. Theuri.
So sorry, Melody, I'm sorry. I tend to watch the hand of the court much clearly when I'm in open court. There are good pineapples there, so definitely I'd rather be making my way down.
Okay, proceed. I'm at the point
So
where
I was saying that there was
you are saying that there is an issue you will raise over the exercise of powers by PJ in view of the fact that the Kisii matters were not before him. Proceed.
Yes, the files were not before the judge at the time he was making the order for that they be consolidated.
Yes.
And already, the problem we have is that Mr. Katwa had actually filed an application for the recusal of the judge in High Court. in those matters. And so, by the transfer of those files, it technically allowed the application that have been filed by Mr. Katwa for recusal. But we will address that at a later date. But the other critical question, the other issue that I just want to bring to your attention is that there was also another petition. That is Nairobi petition 159 of 2024.
Yes.
This petition was filed in Nairobi
Yes.
at the Constitutional Division, and the Constitutional Division, in our view, unlike in Machakos, did the right thing to Kisii. So as it stands, the petition 159 of 2024 is transferred to Kisii. I'm sure it probably has a new number in Kisii. And my lord, that is also part of the files, that the directions by the PJ were that you bring all those files so that they can have together with what was then commercial petition number 3 of 2024, which is now number 1 before you in the mail. So my lady, that is the reason why those petitions were then transferred. The Machakos petitions were transferred because of the reasons that we have highlighted, and the other petitions were then for you to call from Kisii for purposes of giving further directions in terms of the consolidation. And I think it is important for us to indicate at this stage that one of the things that we will be addressing before you would be whether those directions actually by the PJ are actually proper in view of one or two of the issues that we have raised, so that really as you retire to craft your directions, I think it is important that I bring to light those facts because they are extremely important in terms of the determination of the cases and any further directions that the court can give in this one. Thank you.
I don't, just one moment.
I began by saying that the court has grasped with clarity the positions in this file and deemed it fit that it needs to go and acquaint itself sufficiently. One thing, your ladyship, that has not been mentioned before you is that petition number 7 was from Machakos. It was transmitted to the principal judge with a date for 22nd of April for a mention. But in the wisdom of the principal judge, he issued us with a notice that the matter was then brought forward to the 9th. And on 9th, your leadership, further orders were issued by the principal judge that the matter be mentioned before you to date. And we take note, your leadership, that the file is not before the court. While we were before the principal judge directed that that file be mentioned along other files. There were no orders of consolidation. We challenged the court to tell us the status of the orders that have been issued in Machakos. The orders of status quo. noting that the application was then supposed to be mentioned on 22nd, but then brought forward to 9th and then to date.
So you inquired on what? On the status of the orders?
Yes, the status quo order that was granted. The purpose why we challenged the court was that in our thinking that the orders generally do lapse on the date the matter appears before the court. So to date, there are two things that have transpired. One, the file is not before you. And the date for appearance before the court is the 12th of April. Our interpretation is that there cannot be orders that can be extended. As sought by my large senior Mr. Kigen. And that upon the arrival of the date to appear before your leadership and the absence of the file, then your leadership, the court's hands are tied. Number two, your leadership, is that the other file that had orders was the petition number 1, which neither me nor Mr. Kigen have audience, because we have not been enjoined. We have not been joined to that proceedings. The only person who can seek the extension of his orders, if he so wishes, is my learned senior, Mr. Muli. Mr. Muli is the one who knew why he sought the orders. If he needs to sustain them, if he doesn't need to sustain them, that's up to him. But from the bar where we sit, myself and Mr. Kigen, we have no capacity to urge this court to take any further step. Insofar as petition number 1 is an issue, until the date we are going to be enjoined, and until the date the withdrawal is determined. Finally, your leadership, as well captioned by my learned senior Mr. Theuri, before I invite Mr. Monda just to make a remark, is that we are seriously constrained to say and to state that the principal judge exceeded his mandate under Section 6 of the High Court Organization and Administration Act. Section 2 and Section 6 of the High Court Organization and Administration Act, Cap 8C. We are further constrained to say that the orders of consolidation being addressed by my learned senior Mr. Kigen, in light of the sections I have quoted, may not be well sitting, but we shall address that, because this court is still possessed with sufficient jurisdiction to put the orders or the records into proper perspective, because it's a court of concurrent jurisdiction. Noting that whatever I am raising is not an address seeking to appeal, but seeking to bring to the attention of the court the anomaly. And it's a legal anomaly that is statutory in nature, which the court can rectify the records. As well captioned by the court, the Kisii files are not before you. A judge of concurrence jurisdiction is seized of those matters with a date of the 15th of April and the 16th of April having been ordered by the court to appear before that court. And for good order and for good purpose of these proceedings, the court of concurrent jurisdiction, both the principal judge, this honorable court, and the Kisii court, cannot be seen to override over each other or to usurp. We just urge your leadership until the question of my audience, Mr. Katwa Kigen's audience, is determined, then we cannot address you. If Mr. Katwa Kigen was desirous of getting a conservatory order, there is nothing that stops him from moving you appropriately with a petition or an application for conservatory orders under Article 23 of the Constitution. But he cannot write on something that is not in existence and purport to claim that this is public interest. His client is always affected by the proceedings of the Senate. If he is so concerned and so aggrieved, he should have been the person, the right person to appropriately move him and not become a joyrider. Leadership, permit me to invite Mr. Monda.
Apologies, before proceed, there is an issue attached on this petition that I wish to address you on. That is petition P7.
But before Mr. Monda addresses you, can you allow me to make a brief rejoinder?
No.
Just 1 minute alone. For the court forward.
On what Mr. Ndegwa has just sentimented before the court.
Your name again?
Yes, sorry, Corey, for one of the petitioners in one of the Machakos matters, that is E007-24, here together with Ms. Susan Kemunto. Indeed, we had your sentiments, my lady, that you were not well acquainted with all these files, and all these things are new to you.
Yes.
So we do not wish to perturb you with all these petitions and applications.
Yes.
We need you to get time to look at them in the first instance. Now, my colleague said that there are orders that were issued in the petition E007, and those orders were meant to preserve the substratum of the petition, not just this petition, but attaches to all other petitions. Yes. Order. Yes.
Or the order.
Oh yes, or the order.
So, but still, I will hear what you are saying.
Yes. So this order was issued just to preserve